Hello friends, how are you? Happy New Year. Today I am going to share this video in respect of the provisions of section 135 of the Trademarks Act. Reason? Sometimes it does happen that the person who is going to file a suit may not be aware regarding the prayer, what should be asked, what should be sought from the court. Hence, this provision plays very important role. As far as the suit pertaining to the infringement of the trademark is concerned or passing off is concerned. Now, the question arises in the common person's mind that whether this prayer sought in the plaint is granted mandatorily. The answer is not. The answer is no. The prayer sought in the plaint or in an injunction application is based of our case, but it is not compulsory or mandatory for the court to grant all the prayers. It is the discretionary power of the court to grant any prayer, all prayers, or not to grant any prayer. Now, let me tell why this provision is important. Because sometimes I come across many of the plaints, and sometimes I do find that where is the plaint is lacking of prayers, or the plaint is lacking of proper prayer. There is no proper prayer. There is no specific prayer mentioned in the plaint. Unless specific prayer is mentioned in the plaint, no court would grant any relief. That is why this section is very important. Now, as far as injunction is concerned, permanent injunction is related to plaint. Temporary injunction is related to an injunction application under Order 39 Rule 12 of CPC. Whether ex parte should be granted or not, while we are going to file a suit, other side is naturally not remain present at that time. However, at that time, in absence of other side, in absence of the defendant, ex parte injunction to that particular defendant is available or not? The answer is yes, it is available. It is mentioned in the provisions of 135 subclause 2 of the Trademark Act. However, it is not mandatory. I repeat, it is not mandatory to grant the prayer. It is even not compulsory to grant the prayer. It is the discretionary power of the court whether such prayer should be granted or should not be granted. Now, injunction, this is the one prayer. What is the other prayer? Or what is the other remedy to be asked from the Honorable Court? First of all, to restrain the defendant not to use the trademark in any mode. I'm not going to repeat the entire prayers of the plaint, but this is the remedy available under section 135. Second remedy, you may ask damage or account profit from the defendant, provided that the plaintiff has to prove the case. Otherwise, naturally, no damage, no account profit would be available. Now, other remedy, discovery of the documents of the defendant. Second, next one is preserving of the goods, documents, or other evidence which are related to the subject matter of the plaint or of the suit. This is the remedy available. Third, naturally to restrain the defendant. So I'm not repeat every now and then that to restrain the defendants, all the heirs and executives and all those things. So first remedy, injunction. Second remedy, either damage or account profit. Third remedy, discovering of documents. Fourth one is preserving the infringing goods, documents or other evidences related to the suits. So friends, these are the remedies available under section 135 of the Trademark Act. I hope you like this video. Please repeat, please mention, please have some comment, please make some comment in this regard, so that whether I am having if you have any good suggestion from, if I have some good suggestion from your side, that would be grateful for me to make more and more videos in this regard. Naturally, I am going to make videos more and more, but your suggestions are always welcome. Thanks a lot. Thank you very much.